Shawn Ryan recently gave Governor Gavin Newsom a firearm during his podcast.
So everybody gets a gift.
Oh, geez, what do you got, man?
Here we go. You ready for this?
Oh, Jesus.
So that is a California compliant Sig Sauer P365 macro. I'm hoping you brought me some California gummy bears.
Brother.
Shawn then told the governor, I wish you would have brought me some THC gummy bears. I got to thinking, does he recognize the severity of the offense if he were to do that in Florida, possess a firearm at the same time he was possessing THC gummies? I don't think so. And I don't think you do either. Let's talk about it. Florida government as a whole does not like marijuana, and they certainly don't like combining marijuana and firearms into the same conversation. I dove into the numbers to see if there was a correlation between marijuana charges and firearms charges in Central Florida. You'd be shocked at what I found. Florida Statute 790.06 subsection 2 makes it a felony to possess a firearm in Florida while you're committing another felony. And if you didn't know, possession of THC gummy bears without the proper medical marijuana card is a felony. The only version of misdemeanor marijuana in Florida is possession of flower marijuana less than 20 grams. If you have no medical marijuana card and you have a THC vape pen in your center console and you have a concealed firearm on your hip and you get stopped like that with the wrong officer, you're looking at a second-degree felony as well as a third-degree felony and looking at a maximum exposure of 20 years in prison. That's serious. Have you ever heard of Florida's 1020 life laws? You're in the same ballpark. The difference being the underlying felony in the 1020 life law has to be a forcible felony. So you're one step away. Sorry for the interruption. I'm preparing a follow-up video for this, so I'd appreciate it if you left your questions and comments down below so I can be sure to address those in the follow-up video. Hit that subscribe button while you're there. I've been collecting and analyzing Clerk of Court arrest data for the past several years. I crunched the numbers as it relates to this topic. It's complicated, but my initial assessments support this conclusion, and it's worthy of discussion. 30 people were charged with possession of marijuana over 20 grams, and 25 people were charged with a very similar possession of cannabis. Now, I haven't been able to look at the details to find out whether this is 55 people or whether there's some overlap there. But even individually, these numbers are substantially higher than any other secondary offense. The top charge being possession of drug paraphernalia, which doesn't qualify because it's a misdemeanor. The second charge being possession of cannabis under 20 grams, which doesn't qualify because it's a misdemeanor. The next highest charge is possession of cannabis over 20 grams. The data also shows that a very small number of officers are making a large portion of these arrests. But this isn't just about the charges, it's about the results. Because you're charged with a second-degree felony, most of the time, that's not going to qualify for a first-time offender program. You're going to have to face that charge. That means there's a high risk of you being a convicted felon. This is where responsible marijuana users and gun owners are going wrong. If they're only using marijuana for personal use, there's no need for them to carry around with them over 20 grams. That way, if you're stopped and something comes up, at least you're not charged with that second-degree felony. You'd be looking at a misdemeanor possession of marijuana and potentially a firearms violation. Maybe. What did Grandma used to say? 19 grams of prevention is worth $7,500 in legal fees. Did you know if you're charged with a drug-related offense, your medical marijuana card is suspended? The law just changed. I made a video about it and placed the link to it right there. Hit it hard.